Drake is finished. Not tomorrow. Not next month. Right now. And by the time you reach the end of this video, that sentence is going to feel less like a headline and more like a courthouse verdict already scribbled in ink, because what just detonated inside a federal courtroom in New Mexico is the exact scenario Drake's legal team has been sprinting away from for over a year. The Toronto Ghost thought he could bury this. He thought arbitration would swallow it whole. He was dead wrong. And I need every single one of you locked in, because the details slipping out of this jurisdiction are so radioactive that if the judge swings the way the plaintiffs are begging him to, the entire stake empire that Drake has been quietly propping up on kick streams and late-night dice rolls is about to be dragged out of the shadows and dropped on a public docket for the whole world to autopsy. This is a federal filing dated August 13th, and it is the single most dangerous piece of paper Drake has been forced to reckon with in the entire 2-year arc of this stake saga. Before we dive any deeper, do me one favor. Smash that like button. Not just tap it, hammer it. Send a signal. Because the meltdown crowd defending this man online has been trying to bury every honest breakdown of what's actually happening in these courtrooms, and the only way we push back is by stacking numbers on videos that tell you the real story. Subscribe if you haven't. Ring the bell. Then buckle up, because this New Mexico filing is the ugliest legal document Drake has faced in this entire saga, and almost nobody in mainstream hip-hop media has actually read the fine print. I have. And what's inside it is worse than anyone is telling you. And by the time we close the loop on this one, you are going to understand why Drake's legal team has been operating like a house on fire for the past 4 weeks. Here's where we stand as of this week. Drake, Stake, and Adin Ross are being sued across a patchwork of American states in a lawsuit that has now morphed into something none of the defendants expected. What started as a single class action complaint about alleged gambling losses tied to stake.us promotions has fractured into a multi-jurisdictional war zone, and each federal judge in each state is treating the same evidence in dramatically different ways. Virginia, done. Sent to arbitration on July 30th, South Carolina, done. Stake won that arbitration push too. Minnesota, though? Minnesota flipped the script entirely. That judge refused to compel arbitration, and Stake had to run screaming to the 8th Circuit begging for an appeal, because the moment a federal court refuses to lock these cases behind closed doors, the entire private settlement strategy Drake has been leaning on starts to collapse in slow motion. And once that strategy collapses, every other state where a suit has been filed becomes a new battlefield, with a new judge, a new set of rules, and a new opportunity for Drake's opponents to force the entire operation into daylight. And now New Mexico. That's the arena. That's where the next domino falls. And that's why Drake's lawyers have been white-knuckle stressed for the last 2 weeks, because Chief U.S. District Judge Kenneth Gonzalez has a decision sitting on his desk that could reshape this entire lawsuit, and the plaintiffs are pressing every button, pulling every lever, and burning every candle to make sure the judge doesn't send this one behind the arbitration curtain. The filings tell you exactly where the temperature sits, and the temperature is boiling. An August 13th joint status report reviewed by All Hip Hop laid out the fight in cold, brutal detail. Plaintiffs Nathaniel and Rory are demanding one of two paths. Either the judge grants them another 90-day pause so they can keep building their case, or, and this is the play they really want, the judge greenlights court-approved discovery into how Drake's stake campaign specifically reached New Mexico residents. Discovery is the nuclear option here. Because the second discovery is authorized, Drake's promotional records, his Kick.com analytics, his subscriber breakdowns, his marketing contracts, all of it becomes fair game, and Drake's entire, I didn't target New Mexico specifically, defense turns to ash in real time. That is not a small development. That is a paradigm shift in how this litigation gets fought from this point forward. Let me read you the exact language the plaintiff's lawyers put in that filing, because it's surgical. They wrote that without discovery, they cannot ascertain the exact number of New Mexico residents who subscribed to Drake's Kick.com channel, or who Drake targeted with promotional content that convinced them to use stake.us. But then they hammer this line home. They argue the court can reasonably infer from Drake's substantial follower count and widespread influence on young people nationwide, that Drake has conducted at least a single transaction within New Mexico. 1. That is the entire legal threshold. They don't need thousands. They don't need hundreds. They need one New Mexico resident who Drake's promotional machine convinced to hand money to Stake, and the state's long-arm statute kicks the door in. One transaction. One user. One receipt. That is the entire bar the plaintiffs have to clear, and once you understand how low that bar sits, you start to understand why Drake's team is treating this filing like an active fire in the room. This is where the Toronto side of this case gets terrifying for Drake. Because Drake filed a sworn declaration earlier in the proceeding, and that declaration is going to age like warm milk in a heat wave. In it, Drake claimed he never directed, tailored, or targeted his stake.us related promotional content specifically to New Mexico residents or to the New Mexico market. He said he never created stake-related content with the intention or understanding that it would be used to advertise stake specifically in the state of New Mexico. Read that twice. Because that is the flimsiest legal fig leaf I have ever seen a rapper of Drake's stature try to hide behind. Drake is a global artist. Drake's audience is not zoned by zip code. Drake's kick stream to every corner of the internet, and pretending that his stake promotion somehow magically stopped at the New Mexico state line is a defense so absurd that even Drake's own team probably winced when they filed it. Here's the reality nobody wants to say out loud. When you have Drake's platform, you're not targeting New Mexico, you're carpet bombing the entire American map with promotional content, and New Mexico is just one square on the map. The plaintiffs know it. The judge knows it. And more importantly, the state corporate machine knows it, which is exactly why they are throwing every arbitration lever they have at the wall to make sure this case never sees the inside of a jury box. When Drake tweets, every state hears it. When Drake streams, every state watches. When Drake endorses, every state converts. Now let me walk you through the strategic terrain, because this is where the layers stack and the story gets absurd. Drake and his co-defendants have a very specific playbook. That playbook has one page, and one page only. It is called, Get This Into Arbitration. Every state, every filing, every judge, every hearing. Arbitration. 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 And the reason they are chanting that word like it's a prayer is because stake.us buries a mandatory arbitration clause deep in its terms of service, and every user who signed up for the platform technically clicked, agree, on that clause. That clause is stake's shield. It's Drake's shield. It's Adin Ross's shield. It defaults every single dispute out of federal court and into a private, sealed, behind closed doors arbitration proceeding where there is no jury, no judge robed on a bench, no discovery process the public can access, and no verdict a reporter can read. For anyone watching this who's never dealt with the American legal system, let me explain what arbitration actually means, because most people don't. Arbitration is a private alternative to court. Instead of a jury or a judge, you get an arbitrator, usually a retired attorney or judge who has been hired by both sides, and they hear the dispute in a conference room somewhere. In theory, an arbitrator is neutral. In theory, they hand down fair rulings. In practice, arbitration heavily favors the corporate defendant because there is no public record, there is no press coverage, there is no jury of ordinary people who might sympathize with the plaintiff, and there is no discovery avalanche that dumps damaging internal emails into the news cycle. That is why Stake wants arbitration. That is why Drake wants arbitration. That is why Adin Ross wants arbitration. Because if this case ever goes public in a real courtroom, with real discovery, with real subpoenas, the internal machinery of the Stake promotional operation becomes visible to the entire music industry, and to every state attorney general with an appetite for headlines. And once one state attorney general starts pulling that thread, they all start pulling that thread, and suddenly Drake is not defending against two plaintiffs anymore, he is defending against a rolling wave of enforcement actions. But here's the twist. Not every judge is buying it. Not every state is caving. And that is why this New Mexico decision matters more than any single ruling in this entire multi-state saga. The jurisdictional clash currently unfolding in Judge Gonzalez's courtroom arrived on the heels of that Virginia arbitration ruling from July 30th. The new filing lays out the scoreboard in blunt terms. Stake 1 arbitration in Virginia. Stake 1 arbitration in South Carolina. But Minnesota's judge refused, and Stake was forced to run to the 8th Circuit Court of Appeals to challenge that refusal. That mixed scorecard is what makes New Mexico the tipping point. Because if Judge Gonzalez sides with Minnesota's read of the law, then suddenly the arbitration wall isn't a wall anymore. It's a fence with holes in it. And every plaintiff in every other state that hasn't ruled yet is going to be running toward those holes with a fresh amended complaint. That is how a courtroom in Albuquerque becomes the epicenter of a nationwide legal earthquake, and that is why every serious observer of this saga is treating Judge Gonzalez's pending decision as the most important pivot point in the entire multi-state litigation. Drake's attempt to force arbitration in New Mexico began with the same allegations that have followed him across the country. The claim that his stake promotions were designed to funnel young, impressionable audiences toward the gambling platform, that these audiences suffered financial losses as a direct result of his influence, and that Drake, Stake, and Adin Ross should be held liable for those losses under a variety of consumer protection and civil racketeering theories. Drake's response has been consistent. Deny, deflect, and demand arbitration. But denying that you targeted a specific state when your promotional content reaches every phone in that state is legally the same thing as denying that water is wet. It is the kind of defense that only works if the judge is willing to accept an argument that ignores the basic architecture of how the modern internet actually functions. And most federal judges are not that generous. And that's when the plaintiff's next chess move enters the frame. They are asking Judge Gonzalez for one of two things. Option 1, extend the stay another 90 days so they can continue building their case with additional evidence. Option 2, which is the one they clearly prefer, unlock court-approved discovery into Drake's promotional apparatus so they can pull the actual receipts. If discovery is granted, the plaintiffs get to demand documents that reveal exactly how Drake's stake promotion campaign was structured, exactly who it was aimed at, exactly what its geographic reach was, and exactly how much revenue Stake generated from users Drake pulled in. That is a scenario Drake and Stake will do absolutely anything to prevent. Because the moment those documents hit a docket, the arbitration argument disintegrates. The moment those documents hit a docket, other state attorneys general start filing their own actions. The moment those documents hit a docket, Drake's carefully curated public image as a benign brand partner explodes. And the moment those documents hit a docket, every advertising executive in North America starts rewriting the endorsement compliance section of their contracts, because Drake's exposure becomes the case study for what not to do. That is why the Drake loyalty line online is in full panic mode right now, whether they realize it or not. Every stream, every tweet, every comment thread defending Drake as some untouchable global icon is happening while a federal judge in Albuquerque is quietly holding the pen that could rip the entire stake operation into the open. And the loyalists have no idea, because their favorite artist has spent the past 2 years pretending this lawsuit didn't exist, and mainstream music media has been too scared to press him on it. That is not journalism. That is protection. That is the industry closing ranks around one of its most valuable assets while ignoring the fact that the legal system does not care about industry rankings, industry loyalty, or industry favors. The legal system cares about filings, evidence, and rulings, and none of those three variables are trending in Drake's direction right now. Let me hammer this next point, because it is the single most explosive line in the entire August 13th filing. The plaintiffs argued that the court can reasonably infer, based on Drake's substantial follower count and widespread influence, that he has conducted at least a single transaction within New Mexico. That one transaction, is the entire trigger for New Mexico's long-arm jurisdictional statute. If the plaintiffs can prove that one New Mexico resident was influenced by Drake's stake promotions to deposit money on stake.us, the case stays in New Mexico federal court, discovery becomes not just possible but nearly guaranteed, and Drake's entire arbitration wall collapses in this specific jurisdiction. This is the lynchpin. This is the load-bearing column of the entire plaintiff's strategy. And it is a lynchpin built specifically to be almost impossible to knock loose, because the mathematics of Drake's audience footprint make it statistically absurd to argue that not a single New Mexico resident was reached by his content. Drake's declaration that he never targeted New Mexico specifically is going to be tested against reality. And reality does not lie. Reality is that when Drake goes live on Kick, New Mexico residents watch. Reality is that when Drake tweets about stake, New Mexico phones light up. Reality is that when Drake mentions a promo code, New Mexico wallets open. Any argument that says his content magically didn't reach New Mexico is contradicted by the basic architecture of every social platform he uses. And the plaintiff's lawyers are betting, correctly in my view, that a federal judge is going to see through that argument the second he reads it. Because judges are not stupid. Judges are not disconnected from the internet. And judges do not accept arguments that pretend geographic borders exist on platforms that are explicitly designed to erase geographic borders. And here is the part that should genuinely alarm every Drake defender online. because this is where the escalation ladder gets steep. The defense's own filings reveal that Drake and Adin Ross want the current stay only partly lifted so they can refile dismissal motions while Stake's arbitration request awaits a ruling in Illinois. Read that sentence again. The defense is asking the court to let Drake and Ross fight the case on a separate track while Stake fights on the arbitration track. Why would they want that split? Because they know arbitration might fail. They are hedging. They are quietly admitting that the wall might not hold, and if it doesn't, they want a dismissal motion already teed up so they can dodge the discovery avalanche a second way. That is not the behavior of a legal team that thinks it's winning. That is the behavior of a legal team that is preparing for the possibility of catastrophic exposure. And when Drake's legal team is preparing for catastrophic exposure while publicly acting like everything is fine, that is the exact moment every Drake fan should be paying attention. Judge Gonzalez has not yet ruled. The plaintiffs have proposed a status report deadline of November 11th if the stay is extended another 90 days. So we are looking at a possible 90-day countdown clock, at the end of which either this case gets kicked into arbitration and disappears into a private conference room forever, or it explodes into public discovery and becomes one of the largest celebrity gambling lawsuits in American entertainment history. There is no middle ground. There is no soft landing. There is no scenario where this quietly fades away, because the plaintiffs have made it their entire strategic mission to prevent quiet fadeaways from being an option. Let me pause here and level with everyone watching. I have been tracking this Stake saga since the very first Missouri filing. I have read every complaint, every response, every judicial order. And I am telling you, with zero exaggeration, that the New Mexico jurisdiction is where the momentum is currently flowing. Because unlike Virginia, unlike South Carolina, the New Mexico complaint was drafted with the assumption that Stake's arbitration clause would be challenged, and the plaintiffs' lawyers have layered their arguments specifically to survive that challenge. They aren't hoping Judge Gonzalez sides with them. They are boxing him into a legal corner where the only intellectually honest ruling is denial of the arbitration motion. Whether he takes that bait is a separate question. But the trap is set, and the trap is elegant, and the trap has been engineered by lawyers who have studied every previous ruling in this multi-state fight and reverse-engineered the arguments that failed elsewhere. Now let's talk about what happens if Judge Gonzalez sides with the plaintiffs. If arbitration is denied in New Mexico, the ripple effects are immediate. First, Stake and Drake are stuck in federal court in that state, meaning discovery becomes the next major battle. Second, the plaintiff's lawyers can start subpoenaing Drake's kick analytics, his internal Stake partnership contracts, his promotional content approval chains, and any communication between Drake, Adin Ross, and Stake executives that could show intent to promote in states where such promotion would be legally suspect. Third, and this is the domino nobody is talking about, other plaintiffs in other states who currently have their cases stayed will file emergency motions using New Mexico's ruling as precedent, arguing that if arbitration fails in one federal district, it should fail in theirs too. Fourth, and this is the domino that keeps corporate legal departments up at night, insurance carriers backing Stake's endorsement contracts may start re-evaluating their coverage exposure, which could force Stake into a defensive settlement posture faster than anyone expects. That is how a single ruling in a state most people can't find on a map without help becomes the earthquake that shakes an entire multi-state litigation. That is how a jurisdictional footnote turns into a headline that dominates the culture cycle for months. But let's say the opposite happens. Let's say Judge Gonzalez looks at the Virginia and South Carolina rulings and follows their logic, ordering the New Mexico case into arbitration. What does Drake gain? He gains privacy. He gains time. He gains the ability to continue promoting himself as a global icon without a discovery-fueled news cycle hanging over him. But he does not gain a win. He gains a delay. Because arbitration doesn't dismiss the underlying claims. It just moves them into a sealed process where the plaintiffs still get to pursue damages, still get to seek payouts, and still get to force Stake into settlement math. And even a private settlement, if it ever becomes public through a leak or a required disclosure, would confirm what everyone in the industry already suspects, which is that the Stake promotional model has legal exposure baked into its DNA. Delay is not defeat of the claim. Delay is postponement of the reckoning. And postponement in celebrity litigation is often just another word for a slow-motion loss. That is why I keep saying this. Drake cannot win this fight. He can only slow it. Every 90-day stay is a stall. Every arbitration order is a curtain, not a verdict. Every dismissal motion is a delay tactic. The underlying question, whether Drake's promotional relationship with Stake exposed young audiences to financial harm and whether Drake bears legal responsibility for that harm, is not being answered. It is being deferred. And deferred questions in high-profile litigation have a way of returning with more damage attached. Because every quarter this case remains open, more evidence emerges, more filings get docketed, more plaintiffs get emboldened, and more state regulators start paying attention. Time is not on Drake's side. Time is the plaintiff's most reliable ally. Now let's zoom out and put this in cultural context, because this is not just a legal story. This is a hip-hop story. This is a moment in the culture where one of the most powerful artists of the last 2 decades is being dragged through federal courtrooms in multiple states, facing allegations that his promotional endorsements caused real financial harm to real people, and the reaction from the corner of the internet that considers itself Drake's biggest defenders has been to pretend it isn't happening. That silence is deafening. Where are the podcasts breaking this down? Where are the mainstream hip-hop platforms interviewing the plaintiff's lawyers? Where are the industry voices asking why Drake's team is fighting this hard to keep the case private? The silence is not accidental. It is engineered. And it is why independent breakdowns like this one exist, because if we don't tell you what's happening in these court filings, nobody will. This is the media void that Drake's team relies on. And this is exactly the media void that independent creators are increasingly refusing to honor. Let me be crystal clear about something. Drake is entitled to a defense. Drake is entitled to due process. Drake is entitled to argue jurisdiction, argue arbitration, argue anything his lawyers can conjure. That is how the American legal system works. But Drake is not entitled to public silence. He is not entitled to a media pass. He is not entitled to have every hip-hop platform treat this as if it doesn't exist. And when a federal judge in New Mexico is about to decide whether Drake's promotional apparatus will be publicly investigated or privately buried, every single fan of the culture has a right to know what is actually being argued in that courtroom. Transparency in litigation is not a favor. It is a floor. And Drake's team has spent 2 years trying to argue the floor should be lower for him than it is for everyone else. That argument is not aging well. Because let me tell you what happens if this case goes public. Discovery in a lawsuit of this magnitude means depositions. Depositions mean sworn testimony under oath. Sworn testimony under oath means Drake, Adin Ross, and Stake executives sitting in a conference room across from plaintiffs' attorneys answering pointed questions about how their promotional campaigns were designed, who they were designed for, what audiences they targeted, and what they knew about the financial impact on the users who followed those promotions. That is a scenario that has kept lawyers in Toronto and Melbourne up at night for the past 6 months. Because the moment Drake sits for a deposition on this topic, one wrong answer, one contradicted statement, one email pulled from discovery that undermines his sworn declaration, and the legal exposure balloons overnight. Depositions are where narratives die. Depositions are where prepared statements collide with contemporaneous evidence. And depositions are the last place a defense team wants their high-profile client to be sitting when their pretrial defense has been built on the premise of geographic non-targeting. That is why Drake filed that declaration claiming he never targeted New Mexico specifically. He was locking in his story early. He was trying to freeze his narrative before discovery could contradict it. That is a standard legal maneuver. But it is also a maneuver that only works if arbitration succeeds. If arbitration fails and discovery begins, that declaration becomes a piece of evidence that plaintiffs' lawyers will use to trap Drake in inconsistencies. Because I promise you, there are kick-stream clips, tweets, promotional emails, sponsorship agreements, and internal stake documents that will make the phrase, "I never targeted New Mexico specifically," look like the flimsiest sentence Drake has ever put his signature under. Sworn declarations are handcuffs. They lock the declarant into a version of the story that must remain consistent with every subsequent piece of evidence, and any deviation becomes cross-examination fuel. Drake's team knew this when they filed it. They also knew arbitration was their best chance to make sure that declaration never got tested. That gamble is now approaching a moment of truth in a New Mexico federal courthouse. And the plaintiffs know this. That is exactly why they are demanding discovery. They want that contradiction. They want that leverage. They want that trapdoor. Because the second they can prove even one inconsistency between Drake's declaration and Drake's actual promotional footprint, the entire defensive posture crumbles, and settlement becomes the only exit ramp Drake's legal team can afford to steer toward. And a settlement in a case like this is not a small check. A settlement in a case like this comes with confidentiality clauses that are increasingly difficult to enforce, disclosure requirements that scale with the size of the payout, and reputational damage that no amount of PR money can fully bury. Let me tell you what I'm watching for over the next 30 days. First, Judge Gonzalez's ruling on the stay extension versus discovery motion. That ruling could come at any moment, and its language will telegraph everything about how the judge sees the arbitration question. Second, any signal out of the 8th Circuit on Stake's Minnesota appeal, because a ruling there against Stake will send a shockwave through every other federal district considering these cases. Third, any new state filings, because I have been hearing rumbles about additional class actions being prepared in at least 2 other jurisdictions that could stretch this saga into 2027 and beyond. Fourth, any public statement from Drake, Adin Ross, or Stake Corporate, because the current silent strategy is unsustainable, and one of the 3 defendants is eventually going to crack. Fifth, and this is the one I am most curious about, any leaked communications between Stake executives and Drake's management, because leaks in high-profile litigation are not a question of if, they are a question of when. And here is my honest take on the human dimension of this, because we cannot lose sight of it. The plaintiffs in this case, Nathaniel and Rory, are not billionaires. They are not celebrities. They are ordinary people who allege they lost real money on a platform that a global icon promoted to them. Whether or not they win, whether or not this case ever gets in front of a jury, they had the guts to file a federal lawsuit against 3 of the most heavily lawyered figures in modern entertainment. That takes courage. And regardless of where you stand on Drake as an artist, that human element deserves recognition. Because at the end of the day, this lawsuit is not about hip-hop beef. It is not about culture war. It is about consumer protection. It is about whether a person with the reach of Drake can promote a gambling platform to millions of impressionable followers without any legal accountability for the financial fallout. That is the question the New Mexico court is being asked to answer. And that is a question every single celebrity endorsement lawyer in North America is watching with a level of anxiety they will never publicly admit. And that question is going to define entertainment endorsement law for the next decade, whether Drake fans want to admit it or not. Because if the New Mexico court rules in the plaintiff's favor, every future endorsement deal signed by every future artist will be structured around avoiding this exact fact pattern. Every future promotional contract will contain new geographic carve-outs, new disclaimer requirements, new liability caps, and new arbitration clauses designed to survive the specific challenges Drake's team is currently failing to survive. Drake, whether he intended to or not, is about to become the case law that reshapes influencer marketing in the gambling vertical. That is the legacy waiting for him at the end of this litigation, no matter which way Judge Gonzalez rules. So here is where we land. Drake's arbitration wall has cracks in it. Minnesota already punched a hole through it. New Mexico could punch another. If 2 federal districts refuse to enforce Stake's arbitration clause, the entire private settlement strategy collapses, and Drake becomes the first hip-hop artist of his caliber to face full-blown public discovery in a consumer protection lawsuit tied to endorsement activity. That is not hyperbole. That is the trajectory the case is on if Judge Gonzalez rules against the defendants. And the trajectory is not slowing down. The trajectory is accelerating. Drake's team knows it. That's why they are hedging with the split-track strategy of arguing dismissal for Drake and Ross while Stake argues arbitration separately. That is a defensive posture that says, quietly, we are not sure the wall holds. And when a defense team stops being sure the wall holds, you are watching the beginning of a settlement narrative form in real time. Legal teams do not hedge from a position of strength. Legal teams hedge from a position of uncertainty, and uncertainty in a federal courtroom is often the last stop before capitulation. Let me hit you with one more layer, because this is the layer that gets least airtime in every mainstream write-up of this case. New Mexico's long-arm statute is one of the broader jurisdictional statutes in the country. Federal courts sitting in New Mexico have historically been willing to accept jurisdictional theories that other federal districts might have rejected outright. That is not an accident. That is a function of the state's specific approach to consumer protection and its explicit willingness to protect its own residents from out-of-state promotional activity. Drake's lawyers know this. Stake's lawyers know this. And that is why the tone of the Drake team's filings in New Mexico has been notably more defensive than their filings in Virginia or South Carolina. They are not fighting the same fight. They are fighting a harder fight, in a jurisdiction that structurally favors the plaintiffs. And Drake's global brand cuts both ways here. On the one hand, Drake's global reach is his greatest asset. On the other hand, in a jurisdictional dispute like this one, Drake's global reach is his greatest liability. Because the bigger your reach, the harder it is to argue you did not reach any specific corner of that footprint. Drake's own success becomes the very evidence the plaintiffs will use to establish jurisdiction. That is the paradox of celebrity endorsement law. The more famous you are, the easier it is for a court to find that you conducted business in any given state. And Drake, at his current level of cultural saturation, is essentially conducting business in every state, every day, whether he wants to admit it or not. I want to hear from every one of you on this. Drop a comment right now with your read on where this lands. Do you think Judge Gonzalez sends this to arbitration like Virginia did, or do you think he follows Minnesota and forces this case into open court? Do you believe Drake's declaration that he never targeted New Mexico specifically, or do you think that argument is legally dead on arrival? Do you think Stake is going to settle before discovery ever begins, or do you think this ends up in front of a jury? I want your predictions. I want your legal theories. I want your hot takes. Because the more you drop in the comments, the more we can trace where the culture is landing on this before the courts land on it. And listen, before you leave, do the ritual. Smash that like button, because every like on this video is one more signal to the algorithm that people actually care about the real legal breakdown of what's happening to Drake, and not just the surface-level headline recycling that mainstream media keeps pushing. Subscribe to the channel if you have not already, because the second Judge Gonzalez drops his ruling, I am going to be back with an emergency breakdown that same day, walking you through every line of the order, every implication, every next domino. You will not want to miss that. Turn on notifications, because these federal rulings drop without warning. And here is the meta question I want you sitting with as this video ends. If arbitration fails in New Mexico, and Drake is dragged into public discovery, is the culture ready for what those court filings might reveal about the promotional machinery that has been running behind one of the biggest artists of our generation? Because once that discovery door opens, it does not close. And once the receipts hit the docket, they stay on the docket forever. This is not the kind of story that gets tucked back into a folder. This is the kind of story that becomes required reading in entertainment law casebooks for the next 20 years. The Toronto Ghost thought he could bury this in arbitration. He may still succeed. But the curtain's on the floor in Minnesota, and if it hits the floor in New Mexico too, this is going to become the most consequential celebrity gambling lawsuit in modern entertainment history, and every single one of you watching right now will have been in the room when it happened. This is the case future law students will read. This is the case future artists will study before signing endorsement deals. This is the case that redraws the map of what celebrity influence can and cannot legally do. And Drake, whether by accident or by design, is the artist whose name is now permanently attached to it. I will see you on the next one. Stay locked in. Trust nothing you read on the timeline until you have read the filing yourself. And whatever you do, do not let anyone tell you this story is over, because it has barely just begun. Judge Gonzalez has the pen. The plaintiffs have the pressure. Stake has the exposure. Drake has the target on his back. And the culture has a front-row seat to a courtroom drama that is going to define an entire era of the endorsement economy. Peace.